Hi, I'm Greg Pace with Malek and Malek, and we have a hypothetical with the movie Alien. If you were on that ship as a tugboat ship coming back to Earth, and you encountered an alien species, and you were now being told by your employer, you have to capture this alien no matter what happens to you, would that be a valid claim? What do you think?
Yeah, in that case, I agree. If they're telling you to do this activity, it would be in the course of an arising out of employment. Granted, even though as a space trucker or whatever, it's not necessarily your regular job duties, but since you're explicitly said, hey, do this thing, then yeah, I would agree it would be a compensable claim.
Yeah, they're in the movie, their pay is now hinging on them agreeing to get this. So I think that's well established. And what our clients always ask us, and there's usually one answer, but it'd be different here, is can we sue the employer for this? This is clearly a problem that the employer made me do this. Can I sue them? 99% of the time, what do we have to tell clients?
99% of the time, no, you cannot sue your employer. Your sole remedy is a workers' comp claim.
This is pretty extreme, though. You're trying to capture an alien with acid blood that can attach to your face, put weird alien babies in you. That's beyond anything that we would see here on Earth. So what do you think the remedy would be there? Is there another option?
Well, with a workers' comp claim, your sole remedy usually is just a workers' comp claim. Now, you might have, within the workers' comp realm rubric, you might be able to file what's called a violation of a specific safety requirement. That's still kind of within the realm of workers' comp. Now, you could pierce that into personal injury if, one, you have a third party you're suing, or the alternative is you could file an intentional tort. Intentional torts are incredibly rare. Never really happen, and as a remedy in Ohio, they're kind of been eliminated. But that would be another potential remedy, assuming all the facts and the law applies to your situation. So the question is, can Ripley? Well, Ripley, we'll get to whether or not she can, but we're focusing on the guy who got implanted with the Xenomorph.
Yeah, Kane, played by John Hurt in the movie. He does not want to do this. He gets tasked to go investigate this alien species. He touches the eggs. Should he have touched the eggs? Probably not, but he was told to capture the species and investigate. An alien comes out of the egg, attaches to his face. They worry he's dead on the spot. They get the alien off of him. He's in a coma for a while. He wakes up the next day, feels better for a little bit, and we all know what happens. Alien bursts out of his chest. Does that guy have a workers' comp claim? Yes. The question that I have, does he have an intentional tort claim against his employer for putting him in this situation?
So, to correct Mr. Pace, he's dead.
Right. So would his family have a claim? That's a great distinction.
Like a death benefit
Kane is
claim.
dead there. So would this be a death benefit claim? We think you would.
Yeah.
Would the family be able to file an intentional tort? That's the question we want to breach today.
Okay, so it's an interesting question. So an intentional tort, there's roughly three things. So the employer has to have knowledge of a dangerous situation, condition, whatever. I think that's the case. Well, I don't know if that's the case here, but they have to have knowledge of a dangerous condition. They have to have knowledge to a substantial certainty that because of that condition in the workplace, that a serious injury is going to result. And then they need to make the employee do whatever activity that they have knowledge of substantial certainty that it's going to result in a serious injury. They have to make them do that thing. And if they have that client do or that employee do that thing and then they subsequently get injured, then that would be grounds for an intentional tort. The difficulty in all cases, workers' comp or otherwise, and particularly with intentional tort, is proving that the employer. You're having to prove that Weyland-Yutani is the employer in this situation, but you're having to prove that they have this knowledge of all these details and facts. And the problem is how are we going to have? They might have had, and this is where this discussion breaks down. Did they have knowledge that there was this alien species in this derelict spaceship? Probably, I guess, because they're sending them there. Did they have knowledge that if somebody's going in there, did they have knowledge that they're going to look into the thing? I don't know. I think that might be where, because I don't know if they have knowledge that that Kane is going to go look in the silly egg thing, and then it's going to jump and implant him with a xenomorph. So,
and I think for that first question, which I agree, and this is just to illustrate, this is how difficult this would be to prove in this extreme situation. So just imagine the situation you're in on how much more difficult it would be to prove. So here, once they know the alien exists, the employees were still directly being told, you need to go after that. So I think at that point, we would clear that bar on the employer now knows that this is a risk and they are asking the employee to do it. The question is, they know it's a risk, just like climbing onto a roof is a risk, going into flooding basement is a risk. But is that a risk that's expected to cause harm? Is that your main worry?
Here's the problem. Is my main worry is they know that this is dangerous. Here's the thing. This comes up all the time. Clients are like, the employer knows this is a dangerous thing. The problem is did they know that Kane was going to get injured in the precise exact manner that he was? And I don't know if that's it. Just going in there and being exposed around this alien thing is not enough.
Yeah, and this is where discovery is going to be paramount of what can you prove, what can you get the employer to give up in the discovery process. Fortunately for Kane's family, there's one detail that the employer will regret. Ash goes to talk to Mother, the name of the program that they use to get directives from Earth, and Mother directly tells him that priority one is get the alien, and they use a phrase the employer will regret, crew expendable. You don't say that your employees are expendable when telling them a task that you don't expect to be dangerous. If I was in the courtroom, if I was in the hearing room, that would be the main thing that I would be hammering in, is they told this android, not even a human, told this android the rest of the crew is expendable because this alien species is more important than the alien, or than the human life. Bring home the alien, we don't care if the humans are alive. And that is what makes this different from, I was up on a roof that was 3-4 stories tall, that's a risk. The roofers aren't saying, hey, get these shingles on, crew expendable.
Yeah.
But here, Weyland-Yutani said the crew is expendable. And if we're able to get through discovery that printout that says that, Ripley saw this on the screen, she confronts Ash about it, since she's the only living survivor, she'll be able to testify that this was a directive directly from the employer. And I think that is where the courts are now going to consider this to be an intentional tort. What do you think?
Yeah, I'm still gonna break that up, because it's not just that it's dangerous. I think that would not be helpful at all if you got this printout that says it's dangerous. The question is, I don't think there would be no question about whether it was dangerous and whether they had knowledge about the danger. Did they have knowledge of a substantial certainty that Kane was going to get injured in the specific manner that he did? And I think that's where this will be really difficult for Kane to prove, because unless they have like a breakdown, like, hey, if he goes into this thing, he sticks his head, we want him to. I don't even think they told him to do that. I think they just said, go on this silly ship.
Right.
And I think the problem is, and this kind of happens with like warehouse situations or like when people are doing things, it's like these places are inherently dangerous, and I don't think there's any argument about the danger of these workplaces. But does the employer have knowledge of substantial certainty that, for example, one of the leading cases in this area is this Cross versus Hydrokeet, and what ended up happening is this worker had this, I guess they had some kind of boom on like a construction thing, and they were having them work. I mean, this is a little bit more attenuated, but they were having them work around these power lines, and I think you would think inherently, oh, working around power lines is dangerous, but they didn't know they were going to hit the boom and get electrocuted and all that stuff. And so I think that's where this would fail, because I think there's no doubt that it would be workers' comp claim, but the question is, can you prove that they knew that Kane was going to look in the damn egg sack thing? I think that's where it fails.
Right, and I agree. I think that the specifics and the fact here that this is the first time they've interacted with this species might give the employer that out of, we obviously didn't know what was going to happen. This is the first time anybody's interacted with it. So the employer might get away with it from that standpoint of, we didn't know exactly what would happen. But again, as Kane's family's attorney, what I would be hammering in is the they knew something was going to happen or was likely to happen. Otherwise, they would not have even said that the crew was expendable. And will that be enough? I'm not sure. I don't think this gets thrown out on summary judgment, but it may not even be enough in this situation for the win.
Yeah, and the problem is, so when we're talking in these cases and hearing this stuff, there's varying degrees of we have a burden of proof as a plaintiff. So when we talk about workers' comp cases, the burden of proof is a preponderance of evidence. So if you want to put a percentage, that's 51%. So it's more likely than not to be than not to be. So it's barely above half. When you have a criminal case, it's beyond a reasonable doubt, and that's, you're talking like 90% certainty. And the reason why we do that is because we don't want to jail people, because it's, we want to take people's freedom, so we want to have a high degree of certainty. Substantial certainty, that's almost near the beyond the reasonable doubt level of burden of proof. And it can't, the problem is, Greg, in this situation, the Weyland-Yutani and the court might say Weyland-Yutani was negligent, and they were recklessly negligent because they knew this dangerous thing was running around there, or this dangerous environment was the case. They had these eggs all over the place, and somebody might get an egg on might get implanted with this alien, but that might be recklessly negligent. But is that it's beyond reckless. So you could be recklessly you could be a complete nincompoop employer, and you still might not be liable for an intentional tort. That's why it's like the burden is, it's nigh impossible for those things. They happen, but they're like unicorns.
I unfortunately agree, and I think that might even be why in the second movie, who goes after the aliens? Is it employees of a random company? No, it's the U.S. military.
Yeah,
because at that point, the employer no longer has the ignorance defense, because they now know what will happen because they've seen it happen. They have an employee that had it happen, so they send in the military.
Yeah.
So I think even in this situation, it's so extreme, so horrible, the employer is still going to be able to say, yeah, this is bad, we may have messed up, we didn't know what was going to happen. Even though we said the crew was expendable, we didn't know they were going to die. We just said it's okay if they die. So that you're going to probably be out of luck, but I at least think it'd be worth bringing forward.
Yeah, and the funny thing, that it's not really funny when in these dangerous environments, but maybe Alien, it's a fictional universe. Who cares, man? But Ripley is. So does Ripley get injured in Alien?
Yeah, that's a good question before we wrap up. So Ripley's the only survivor. So Ripley, she's probably going to be going through it mentally for the rest of her life. So she's going to call us and say, hey, this happened to me. I'm not going to believe her. She's going to tell me it happened, and I say, okay. And then I'm going to say, well, what are your injuries? And she's going to say, I've got PTSD, I've got depression, I've got anxiety. And what's the problem there?
And what are we going to say? It has to flow from a physical condition. So clearly Ripley has PTSD because she's like having nightmares about the alien bursting through her chest. Unfortunately, she has no compensable workers' comp claim, notwithstanding the fact that she went through this horrible incident. And the other thing is she wouldn't really have any remedy, because there's no intentional tort here, as we've kind of established. So I don't know, she's kind of SOL, man.
So yeah, I think Ripley's out of luck. Not as out of luck as Kane, who's dead, but
Yeah.
she doesn't probably have a claim to file. Maybe some sort of employment claim, but nothing that we'll be able to help with in workers' comp.
Yeah, I mean, she got a pretty cool gun in the second movie.
That's right.
Anyways, one other final thing is, I'm just going to throw this out there. What are they? They're space truckers, right?
Right.
Listen to the song Deep Purple, Space Truckin', if you listen to music today. All right. Thank you for watching this, folks.
Yeah, hope you enjoyed it.